we've got a question that came in from an individual named Bailey. It says, I signed an OTP for a property. The OTP stated that the seller would be responsible to evict a tenant residing on the property. 10 months have now passed and no eviction has occurred. Bailey says, I am now stuck as I am being held to this OTP that I signed. He says, I found an alternative property, which is in my price range, but because of the agent's refusal to release me from the OTP I signed, I fear I will lose out on this deal. And I may potentially be saddled with wasted costs if I pull out. What are my rights in this regard? Bruno?
Okay, so interesting one. And I think this could play in a number of different scenarios. So it's a difficult question to answer that you'd find an application across the board. From what I hear, I'm making certain assumptions now that transfer hasn't gone ahead. The reason I make this assumption is because the viewer is speaking about wasted costs. And if they got the notion of wasted costs, I would imagine that it was the attorney that mentioned it to them. And that would only come into play if the transfer hasn't gone ahead, right? If transfer has gone ahead, the answer would be materially different, because once the property is registered and a bond and the bank pays out a loan, it's a lot harder to get out of a contract. If that hasn't happened and transfer hasn't taken place, it still has a lot to do with the wording of the contract. The reason for this is, remember, in some contracts, certain duties aren't reciprocal. So even though a party is obliged to do something, doesn't necessarily mean that he has to do it before something else happens, right? So that's just one thing to bear in mind. So trying to stop a transfer from taking place because the eviction hasn't been completed might not always be possible, because a lot of the times the eviction only needs to be completed and vacant occupation handed over on the date of registration. So trying to cancel now ahead of time before transfer is even passed might prove difficult. The fact that this contract seems to have been put on hold for 10 months whilst the eviction is taking place in the background gives me an indication that somehow the sellers have accepted that this is the status quo, that the contract is in place, that it's enforceable pending an eviction. And again, depending on the wording of the contract, it might be like a condition, a suspensive condition in the contract that the eviction be concluded. It might just be a term in the contract that it be concluded before registration takes place. Under those circumstances, again, it's the wording of the contract you need to look at. Very often, especially with terms, you'd look at what a reasonable time is. But we've discussed that before on previous episodes. And if you can justify that a reasonable time has lapsed and the eviction is still not taking place, you should be able to cancel the contract based on the seller's non-performance.
Thanks, Bruno. That was actually a very quick answer as well.
I was expecting Cilna to jump in there.
Again, I do want to. Because what I think is handy to know is, I agree with you 100%, Bruno. It's exactly that. I got the same thing, not yet registered. So my advice would be place him on terms, given the time period that you have in terms of the lease of the sale agreement. So typically 7 or 14 days, something like that, depending on the contract. And you cancel the agreement, and there's no chance that you're going to pay any wasted costs, then you have a damages claim against the seller. That's easy enough. But a handy tip that I want to add is, if you do foresee that there's going to be an eviction issue in a sales context, never, ever, 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 did I make it clearish? Sort of. Everybody got my vibe there. Really never agree that the seller will be responsible for the eviction, and he can appoint the attorney and do the whole thing. Because let's quickly call a spade a spade. You will get quotes for evictions of 6,000, 7,000 rand. Eventually it ends up either costing that, but the eviction takes a year or 2 years, because it's a general practitioner that doesn't do evictions often, doesn't know how to do it, doesn't know what to do when they run into issues, or it's a case where the seller, it doesn't have the same urgency as you do. So it doesn't push the situation, and he's not going to appoint an expert. Once again, if you agree to do something, make sure you are in control of getting the thing done. So rather agree to an amount that the seller will either pay to you on transfer, or just a reduction of the purchase price of an amount coming back to the purchaser. And you then instruct the attorneys, but make sure you now leave enough room for potential issues in an eviction, and rather than be responsible for the cost. Because the problem is, if we start an eviction and a sale is underway and transfer takes place, we transfer your locus standi right from under you, and you stand in front of court eventually with a fatally defective application. So so my advice on something like that is, do not agree to the seller doing the eviction, agree to the seller paying for the eviction, but you then being allowed to attend to the eviction as the purchaser, because then you can go to the right attorneys to get that eviction done in a proper time period.